We Indians have a tendency to gauge a person on the basis of his race, caste, religion, or language. Even our rationale for day-to-day activities is based on these factors. While making friends, choosing neighbors, choosing life partners, we generally consider these factors to decide whether the other person is appropriate or not. The very same tactics are adopted by us while electing our representative in parliament and the state legislature. Undue advantage of such practices are taken by our politicians in soliciting votes during election. But have we ever wondered that whether these types of practices are allowed in a secular and democratic country like ours? Abhiram Singh versus C.D Commachen is the case which precisely answered this question. The case arose in 1990 when Abhiram Singh, a BJP candidate who was contesting election from the Santa Cruz constituency in Mumbai, was accused of corrupt practices under Section 123, Subsection 3 of the Representation of the People Act 1951. The provision provides that an appeal by a candidate to vote or refrain from voting for any person on the ground of his religion, race, caste, community, or language shall be a corrupt practice and it shall be prohibited. The punishment for the same offence is disqualification for a period up to 6 years. The primary issue before the court was regarding interpretation of the term his religion. Does the term his refers only to the candidate and thus implies prohibition on soliciting votes on the basis of the candidate's identity, or does it also include reference to the identity of the voter base and therefore prohibits appeal based on the identity of the voters as well? For example, consider two statements. First one being that I am a Tamilian and therefore you should vote for me, and second, I will protect the language that you speak and therefore you should vote for me. Should both these statements be prohibited or only the former one? The case was decided with a majority of 4:3. The court in this case has given a broad and purposive interpretation to Section 123, Subsection 3 to say that both these statements were prohibited under Section 123. The court reasoned that while interpreting a law, one has to not only consider the text of the law but also the legal and the social context in which it was enacted. India is a secular country and thus restrictions on electoral speech had to be read broadly so as to keep elections out of the purview of petty caste and religious considerations.
The court has reiterated the words of Dr. Radhakrishnan and said, and I quote, "We hold that no religion should be given preferential status or unique distinction, that no religion should be accorded special privileges in national life or international relations, for that would be a violation of the basic principles of democracy and contrary to the best interest of religion and government." The court further stated that now the influence of the candidates has been tremendously increased through print, electronic and social media, and therefore it became necessary to ensure that Section 123, Subsection 3 of the Act is not misused by giving a narrow interpretation. On the point of violation of Article 19, Clause 1, Subclause A of the Indian Constitution, the court opined that the provision does not stop a man from speaking. Rather, they merely prescribe some conditions which must be observed if one wants to enter into a parliament.
The right to contest an election is a special right which is created by a statute and can only be exercised on the conditions laid down by the statute. The fundamental rights have no bearing on a statutory rights. By relying on this reasoning, the court held that the term his mentioned under Section 123, Subsection 3 of the Representation of the People Act refers to not only the candidate but also to the voter. That is to say that in an election, a reference cannot be made either to the religion of the candidate or the religion of his agent or the voter. So, if in the forthcoming election, any candidate or his agent appeals on the basis of either theirs or of their voters' religion, race, caste, sex, community or language, then Abhiram Singh is the case we should point them out to. Thank you guys for watching this video. This video was prepared by Constitution Law Society at National Law University, Jodhpur. For watching more such videos and lectures on constitutional laws, please like, share and subscribe to our channel.